we would be able to identify where Tony Okocha, and I'm going to play the soundbite in a bit, where he ordered them, said, see, you must impeach, start the impeachment process, because the governor has, failed to lead the people, and he has disrespected the President of the Federal Republic of Nigeria. Take a listen.
In consultation with my party, we are directing the APC members who are in the assembly to immediately commence the impeachment of Governor Fubara. A government that does not respect the rule of law, what the governor can claim he has achieved is the issue of squandering Rivers money, 150 million naira per LG. Please, knows where they say they're building 20,000 housing scheme. I was there yesterday and I wept. One is building dwarf houses in that very, very important part of the state.
Take a listen to the reply from the Commissioner for Information.
The call is a wild goose chase. If the records must be put straight, the governor respects his president. Nowhere the governor ever, in any attempt, tried to undermine the office of the president. The governor also didn't say he does not recognize assembly. Assembly is a creation of the law. He said those young men who parade themselves as lawmakers, I do not recognize them. They do not exist in part of the process of reconciliation. Mr. President said, go and withdraw. We kept our own part of the bargain. They are not keeping to it. If they recall, there was a time we had the factional house where Edison Ehe presided over as speaker, and he was recognized by Justice Dana Gogo. It was on the strength of that budget was presented to that house, and it was an act. So I don't know how we can re-represent. I don't know how. If the court says, who am I to object or disagree with the court?
On the note, I welcome you to Hard Facts on 92.3 Nigeria Info. I am Kala Dakuru Batu, and joining me right now is a lawyer, a human rights lawyer. As a matter of fact, he is the National Legal Advisor for the Committee for Defense of Human Rights. I'm talking about Henry Ekine. Henry Ekine, good afternoon. Welcome. It's good to have you.
Good afternoon, Kala. Thanks for having me. It's my pleasure to join you this afternoon.
Okay, so you must have followed all of the political intrigues happening in Rivers State. First question I want to throw at you: does the governor have the legal backing to say that he does not recognize the House of Assembly members led by Martin Amewule?
I would say this discussion is within his discretion to recognize who he wants to, but not the Liberty House Assembly. I think I listened to your soundbite of the Commissioner for Information making a distinction between the Liberty House Assembly and then some individual members of that assembly. So I would be careful to say that it is not within the law for a governor to say he will not recognize the House is state part of assembly. Because it's not the context here. But it's within the discretion of the governor to say he has reasons not to recognize certain individuals as members of the State House of Assembly. I think the next question will be to him, why would he not recognize those individuals? And I think in that statement, the answer was probably provided that as far as he is concerned, that those individuals have ceased to be members of the...
Okay, sorry.
That's the context.
Henry,
correct to make that submission.
I would have to pause you, end the call back, because the line is not clear enough and it keeps breaking while you're talking. So network is really terrible these days. Or should we do a WhatsApp call? But if I do a WhatsApp call, I would not be able to take your WhatsApp voice note. So I'm going to go back to the phone lines and see if okay, let's see if we can get a proper connection this time. All right. Sorry for. I mean, a lot of things happening these days. First, the system changes, and then we're trying to get used to it. I'm getting better at that. And now we are having network issues with the network providers, so it's ringing, and hopefully I get Ekine back on the line. All right. Welcome. Can you hear me?
Yes, I can hear you. Can you hear me?
I can hear you clearly now. So you were saying that the governor's got the right not to recognize certain individuals as members of the House of Assembly. Did I hear you correctly? He has the right, legal right?
Yes, that's true.
Can you?
It's within his right. It's within his discretion and within his right. The only thing that a discerning mind would do is to ask him why he wouldn't recognize certain individuals as members of the House. And then he probably would explain like he did. If you cease to be a member of the House, of course you wouldn't expect that the governor will continue to recognize you as one. Or if a dead member of the House, the governor will not continue to recognize. We have had a member that has died. He can't continue to be recognized as a member. If you have eventually a member that has resigned, the chief of staff cannot continue to be a member of the House. The same way to any person who has taken a step that has cost him the seat in that House. It's not just the governor. I think a number of constitutional scholars and those who are objective have since October ceased to recognize those individuals as members of the House of Assembly.
But you see, the law can be complex. I usually would hear lawyers say that you cannot say someone is guilty until he has had his time in court. So innocent until proven guilty. So could it be that the lawmakers are still lawmakers until a court of competent jurisdiction speaks on the matter?
Canada, and that is perhaps the extent they are even to sit now, because they wouldn't even attempt to sit anywhere, even if it's in the auditorium of the quarters. But when it comes to constitutional matters, okay, the Constitution is very clear, and then the courts have already given interpretation what the provisions of the Constitution would be, and then particularly in this regard. But I think that I agree with you, saying that is why I'm aware that these matters are already sub judice, and then they're in court. And then the reason they're in court, I think that those who have gone to court is to present before the court the realities of the provisions of the Constitution, and then the decisions of the Supreme Court, and of course the fact that these gentlemen have actually vacated their, if you like, defected from the political parties that sponsor them to another. So with this fact, the court made the appropriate declarations and orders in the coming days and weeks, I believe.
Okay, so you're saying that it's in the court, so we should wait for the court. But the governor did not wait for the court. Speaking, they are not members.
No, sorry, I think I didn't listen to that soundbite.
Okay.
The governor said to the effect that the extent to which they continue to exist and parade themselves is to the extent that he recognizes them. Again, he has not said he has ceased to recognize them, in the sense that even to the last count, I recall that the Rivers State Public Procurement Law that they just purportedly passed was transmitted to the governor, and he received and made his communication. We told him his asset to the best of what is available in public media. But the statement, I believe, is to the effect that these gentlemen should know that they have, if you like, a clock in their wheel, and that it is easy to recognize them. And you know what? When a matter is sub judice, a subject matter is before the courts, ordinarily, and as a matter of fact, everybody should take action. And actually, it will mean that since the legitimacy of these young gentlemen, their seat is in question, in the capacity.
Sorry, come again. The line was breaking. Sorry, so if it's in court, what did you say? We didn't hear you clearly.
See, clearly, it is not this political matter, right? Once an issue or any subject has become a matter that the court is intending to decide, it is expected that you hold on. Your legitimacy, your membership of the House of Assembly, and your continuing existence has been challenged in court. What then is the court sitting for? If the court does not restrain you to hold your, after all, a House Assembly can adjourn to a date that will not be uncertain. That's when they adjourn Senate die.
Okay, we'll go for a quick commercial, yeah? When I do come back, hopefully we'll have clearer connection. I would ask you about this. If the matter is in court, are they supposed to stop being members?
Hooray! You want study? Work!
With Henry Ekine, National Legal Advisor, Committee for the Defense of Human Rights. You're welcome, Henry. Can you hear me?
Yes, I can hear you, Kalada.
Okay, I think it's a better connection now. So, yeah, before the break, you mentioned and you stated that since the matter is before the court, that means everybody is supposed to stay put. Now, does stay put in any way mean that the lawmakers should not perform their duties? Because some people have argued that, the judiciary cannot stop the lawmakers from performing as lawmakers, neither can they stop the executive from performing his executive duties. So, when they say stay put, can you expatiate on that?
The judiciary really is one of the organs of government, yes. The legislature has a constitutional duty to perform, correct. The executive in the same regard, yes. But when a particular individual, and don't forget that the legislature is a composite unit of the government, and then of course when it comes to the legislature, the tenure or the yes is seen as whole, as one. So but an individual can have his tenure terminated or his seat lost. So you can have an issue in court that challenge the legitimacy of your being a member of the House, especially when that is the subject matter. Arguably, in my view and my position, is that the court can even direct that, hold on, don't perform this function until the determination of this matter. Like I said, if you compare this to several other matters that are in court, that's usually the direction of the courts. I wonder what the difference would be in this regard. If there was a dispute on a piece of land, and then one person is saying the land belongs to him and the other person is constructing maybe some structure on it, and then the subject matter is before the court, which is the land. Usually the court will say nobody should go there at all. Nobody goes to that site. Not even the owner, the person who claims to have the piece of land, not even the person who is building on it until the determination of the matter. In fact, I was in a court where a judge was even saying he doesn't even actually need to even make an order in that regard. That if you respect the authority of the court you have submitted to already, you have activated the jurisdiction of the court, that even without an ex parte order, that the reason he's sitting there as a judge is respected. And then the reason he's sitting there is to make a decision on this issue that you're having a dispute about. So if somebody is continuing to enjoy it and then continue to expropriate the whole thing, what is he still there doing? The same way, at the end of the day, all of this up and down, and then it's held by the court that, look, these 27 members were actually living since October of last year or thereabout, no longer members of the State House of Assembly. So what have they been doing between that period and now? Frustrating the government and then probably orchestrating and causing crisis and talking points. What some of us are even getting tired in giving analysis on these matters, repeating every day from different angles. That it should have been it. And this is a matter that should have been expedited. But we have them going on and still sitting as if there is nothing wrong anywhere.
Okay, and Ekine, let's pause you for a bit now. You've given reference to land matters where the court gives, the order, and everybody waits till a decision is made, a substantive decision is made on that matter. However, some would argue, lawyers of course, that this is a part of government questioning another part of government. Now, for there to be government, there is the executive, judiciary, and the legislative arm of government. So when you say submit, can the legislature, because now when I say legislative, we have 27 members, which is a majority of the legislative arm of government in the state, can they then surrender in that way you've painted it?
See, Canada, when people speak about the rule of law, they seem not to even be objective about it and then look at it from all perspectives to you. Rule of law simply means the predominance of the law, the supremacy of the law above any other discretion. So if the law is to the effect that, yes, the judiciary will interpret the laws, it doesn't matter who is involved, an individual, even if it's Mr. President. So at that time, you're not saying the judiciary is interfering with the executive. The executive structure, okay, let's take the House of Assembly. That's why I made a clear explanation of the House of Assembly. The Constitution of the Federal Republic of Nigeria creates a House of Assembly for each of the 36 states of the Federal Republic of Nigeria. So Rivers State has one. That House of Assembly is different from Mr. Martin Ameule. It's different from all the other 26 friends of his. The Rivers State House of Assembly is a composite entity. It can sue and be sued. No judiciary, no authority can stop the existence of the Rivers State House of Assembly. This is clear, but for those who probably would look at it differently, we'll have an argument about it. It is clearly different from Mr. Henry Ekine if I were a member of the House of Assembly. The House of Assembly exists, but if some 24, 27, 26 members, as the case may be, have an issue before the court as individuals, not as the Rivers State House of Assembly, the court will make a pronouncement with respect to those individuals.
Okay, now
so it is not clearly as it is that's an interference, as if the judiciary is saying the House of Assembly. It is only where the House of Assembly is seen as an entity in regard as being a party in that suit. But I think the question here is not about, people are not saying the judiciary should close down the Rivers State House of Assembly. I think all the matters in court, they are not the only members of the Rivers State House of Assembly. They are not. The Rivers State House of Assembly is a 32-seat House of Assembly. One individual died, they became 31. One individual again resigned, they became 30. Out of the 30, 26 or 27 took a step that has caused this controversy across the country. Everybody is speaking about it. Across the country, colleagues everywhere. And then people have their objective, but we are just here talking
Henry, let's pause now. Let's look at this matter now. For educational purposes, I understand it's before the courts, but some lawyers have argued that it is the speaker. I mean, yes, if you vacate your seat and there is no division in your party or there is no merger, then you are supposed to vacate that seat. That is the law. But then there is the saying, some lawyers are saying that there is the other component of it, that it is the speaker who is supposed to declare the seat vacant, not the court, not the governor, not any other member, but the speaker. And if the speaker in this case now is amongst the people who have defected, then there should be a vote to impeach the speaker, and if it reaches the 2/3 majority, the speaker is impeached, a new speaker comes on board and declares the seats of those who have defected vacant. That is how they have interpreted that part of the law. So what do you make of that? What do you make of that argument?
Kalada, we've all been in this state. What you have just stated has happened in Rivers State now. I say sometimes I'm probably getting tired in even doing some of this analysis. What you have just stated has happened in this state. I just counted the seats in the Rivers State House of Assembly to be 32. We lost one by natural occurrence of death. We had 31 of them were going on. And of course, at the time, 26, 27 of them behaved the way they behaved. You were in the media that about 4 or 5 of them remained as members of the Rivers State House of Assembly. And they had a speaker. And that we are here, the media is across the country. That speaker made this stuff you're talking about as declaring certain seats vacant. Even communicated INEC to that effect. So what you're saying, for those who argued about what you're saying, they are correct. The Constitution is clear. As that happened, you can answer that it has happened. It was after then that even Edison Eye had done that declaration of those seats vacant. He had communicated INEC by the media. We got that report. He had actually convened a sitting with the other members of the House and did some legislative businesses, including the receipt of the appropriation bill when it was laid before the House, and considered that and passed that. And that particular House, led by Edison Eye, which was recognized even by, if you like, if they needed a court order to recognize that, had that legitimacy. And then adjourned that sitting sine die. People have forgotten that there was a sitting that has been adjourned sine die. There are members that are still.
But Henry, Barrister Ekine, now there are people. Sorry, I keep referring because the matter has got to do with a lot of opinions and ideologies. Now, there are people who make reference to Justice Omotosho's court, where the speakership of Edison Eye was nullified. And then if you also look at the process, and people have argued that the process did not go through the right way. Did Edison impeach Ameule, or was it, just, what's the word now, assumed that Ameule and, like you call it, his friends had defected, and so they had vacated their seats automatically, and then it became his responsibility to be speaker. Some people have asked, how did he become speaker? Can you speak on that?
Kalada, as far as I'm not a member of the Rivers House of Assembly, and we all followed all the developments in Rivers State since October of last year, you would agree with me that Rivers State has been so sharply divided by anybody, those who have spoken in that direction, especially those who have refused to be objective on even the issues that are clear. If you are a politician and you belong to one political party or another, perhaps you speak in that direction. But the facts that are clear and that are before us is that they were all members of the House of Assembly. And then they had issues of suspension and crisis that emerged. At the time that we had all of these reports, Edison Eye was the leader of the Rivers State House of Assembly. Martin Ameule was the speaker. But you forget that beyond that point, at the time you never had crisis, beyond the point of normal legislative relationship. Now they had a time that these 27 individuals acted the way they acted. It has remained, even to my colleagues, there are some colleagues that say, Ekine, I think your interpretation is wrong. That's okay, hold it. That's your view. I know that I'm in line with the Supreme Court decision in Ifedayo and Ondo State House of Assembly, and of course with the Constitution. But hold your view. But whatever that is, Kalada, the point I am making in my understanding is that there was a time, I agree with the decisions of concurrent courts. Omotosho is of the Federal High Court, for goodness sake. And then the Rivers State High Court is a court of concurrent jurisdiction with Federal High Court. And there are Supreme Court authorities that you cannot have conflicting decisions when you talk about concurrent courts. In that regard, to the extent that one will submit to the other. These are things that even greenhorns.
Yes, but Henry, the argument is that Justice Omotosho was the first court that they went to, and he asked them to stay put. And I remember calling you at one time.
I agree, Kalada. That's what I mean. There's a matter even in the Rivers State High Court, for instance, now. And then one of the defense of the defendant is that there is, I think that's the one in the Federal High Court. The Federal High Court. A colleague of mine who is handling that had a brief with me. One of the reasons, the grounds of their preliminary objection of the defendants is to the effect that the Federal High Court in Abuja had held one way or the other in respect to these facts that are before this present court. And the court said we are courts of concurrent jurisdiction. It doesn't stop any other person to bring a question before me to answer and review the way I see it, except the superior court. So even if Omotosho's court came earlier, Kalada, have you examined the processes whether they're exactly the same parties? Or even the questions that were before the court were the same? People say a lot of things. Some of these matters, the questions that are before the court, non-lawyers won't understand, but even some lawyers will decide, even when they understand, to decide the other way. The questions put before the court is what the court will answer.
Okay.
If your question is not to another to ask different questions,
okay, let's come to we were to talk about impeachment and we dragged on the other issues. But let's look at the impeachment now. In the thick of events, when this all started, we heard of impeachment. It was even started, but then they went to Abuja, they shook hands, they hugged each other, they laughed, maybe even ate something, maybe had communion of some sorts, and came back to Rivers State and said they have now agreed to an 8-point agenda. right? And part of that agenda, was that the legislators would drop the impeachment process. It had been started. Can a process that had been started, stopped, be restarted? That's the question I want to throw at you. Legally.
Yes, it can.
Okay.
Yes, it can. Kalada, let me even take from the point of view of an action in court. You can actually institute an action in court, and then while it's on, you can discontinue and withdraw that action, and it will be struck out. You can reinstitute it. Perhaps you could discover effects, and then you could actually discontinue that action and reinstitute it even in another court. That's permissible. Then again, attempting to remove a governor, and then at some point you unilaterally on your own stop the process. Okay? And the process didn't get to the end where the court decided that those allegations were unfounded. That would have been where constitutionally you would argue, some lawyers would argue in favor of the victim, that is, say, a governor, that look, you have raised these issues and they've been tried and have been found innocent and not guilty, so you can't raise them again. That's only where it would have gotten to the end. It's just like a criminal trial where a person who has been tried and convicted cannot be tried again, or actually being discharged even, and can also be tried again on the same allegation and then the same parties. So I think in this regard, yes, they can. But the question here is, just like we raised the same questions the earlier time they attempted that removal process, what are the legitimate legal constitutional grounds of that allegation of misconduct? If you have it, the power, I can say clearly to a House of Assembly, the Constitution has vested in the House of Assembly exclusively really the power to begin the process of removal of a governor. No governor can argue that. The power to begin the process, and I'm very determined with my selection of word, to begin, not to conclude. Kalada, let me also even tell you that it is not an absolute power of the House of Assembly to remove the governor. That is to say, it does not start and end with the House. It starts with the House, it gets to another level. I mean, the judiciary will get involved, okay, before it comes back to the House. So it's within the House to start the process. If they have found, probably they missed the first one, they have found another reasonable and justifiable ground to raise the allegation of misconduct, they can do so.
Okay. I've got one final question, because the impeachment story, like you've mentioned, is what is most talked about in Nigeria at the moment. National televisions are talking, radio stations all across Nigeria talking, maybe even outside Nigeria.
I'm sorry, I'm not interjected. There is no notice of removal or notice of allegation of.
Yeah, I know. I'm going somewhere.
I don't want Mr. Tony Okocha.
I'm going somewhere. On social media, actually, it's also trending, even on the front pages, and it is talking about impeachment process. And why it's being talked about is because, like you mentioned, Tony Okocha, who is like the NWC of the APC recognizes, the acting chairman of the APC, is ordering the lawmakers who are in his party, APC, to start an impeachment process or face disciplinary actions from the party. So now the question is, there's the likelihood that they would want to kickstart the process. How difficult is it? Because you've mentioned the judiciary has a role to play. The legislative starts the role, the judiciary continues to roll. But if my memory serves me right, the attorney general or the chief judge, the chief judge also has a role to play. So can you please break it down for us? Let's get here.
Okay, let me start with Tony Okocha. Tony Okocha is within his right to say anything, give any directive to a member of his political party. He's within his right. But sometimes why I worry how we do things. What has that got to do with press interview and us constituting the talking point? But well, it's within his right. And again, he didn't. He has no role. No political party has a role with respect to the process of removing a governor. No individual other than the House of Assembly. So he merely just told his party members in the purported House of Assembly to do that. But let's get to the question you asked. The procedure is this. A House of Assembly that feels, either by an individual or a number of them in the House, that have some allegation of misconduct against a governor, or if it is National Assembly against a president, they will cause a notice to be given to that holder of office, alleging some misconduct. And the Constitution is to the effect that you must say, no, Mr. Governor, you have conducted yourself in this manner, in that manner. You provide the particulars, dates, time, and the details. And again, it's not just about whether you looked the other way, you close your eyes against somebody, or you disrespected somebody. It has to be with respect to the performance of the function of the office of that holder. That is, if it's the governor, is it in respect or in regard to the performance of the functions of the office of the governor or of the president, as the case may be? Then, but for whatever grounds you want to couch in your notice of allegation of misconduct, when you do so, they will now consider it without much argument within the House whether it should be investigated. Kalada, that is where it leaves the House. All these ones were even dragging here and there, House of Assembly, they want to remove governors. They do so. They are no hand, nothing whatsoever to do with respect to constituting the 7 man. So they are not absolute in even removing the governor.
So it's going to be difficult, I mean, given the fact that the chief judge is an appointee of the governor.
No, not quite. I wouldn't quite say so. Especially that's my constituency. The chief judge has an independent mind. Okay. It is not an appointee that is answerable to the governor. Okay. It is only a process that provides for checks and balances. When we say the principle of separation of powers, sometimes people argue about appointments. The appointments in the Constitution to the effect that if somebody is appointed by the head of the executive and he goes to the legislature for confirmation, it's for purpose of checks. So that you appointed a chief judge is not that you answer to the governor even when it's unreasonable. Okay. So I've made that point. Now the chief judge will constitute a panel of 7 men of integrity. All he needs to do is his discretion. It's not even the governor's discretion. It's not the House of Assembly members' discretion. It is not even the leader of a political party's discretion. They will not even play any role in that regard. So the chief judge does that. And when he does that, he gives them this notice of allegation of misconduct. Of course, they will communicate the parties that are involved. It's like a quasi-judicial process. They will want to listen to them and hear them. The Mr. Governor will go there if he wants to appear before them. He has a right to even representation as a counsel, lawyers of his own. He goes there with his SANs. And then those who are alleging will come and prove it too.
Okay.
People don't hear on this and think that if Martin Ameula and his friends say there's an impeachment and the governor is removed, when you allege those gross misconduct, you will come and prove it. It's just like every other matter in court. When you prove it before the panel, whether by giving evidence, providing evidence, proof, and all of that, then the other man too has a right to defend.
Okay.
It takes a period. So when the panel finish, they will have a report. And what the Constitution says that if the panel fails to find those allegations, it ends there. When the panel says, look, these allegations are frivolous and unmeritorious, they lack merit, it ends there. The House of Assembly will do nothing anymore. It's only when that panel finds those allegations as established and finds the holder of the office culpable of those allegations that will make a return to the House of Assembly. That is where they now even have the power they should even be excited, not even this one. Raising an allegation is something people do every day on the street. People accuse people of different things.
Okay, now I do have one final question, and I hope this is not me preempting the court, but talking about the allegation, right? What if we're doing assumptions now, the court swings the pendulum in favor of the legislators? Would it mean that, going by what is, because you said that if the court swings the pendulum in favor of the governor, it means that all the laws and all the bills and all the other things that you have been doing since October will be null and void? So if it goes the other way,
I haven't quite said so, because but just go on with your question, please.
Now, okay, so you can address that as well. So now the question then is, if the pendulum swings in favor of the House of Assembly members, would it in any way, cost the governor some trouble? Because, there's to talk about presentation of the budget. There's to talk about all the things that they have been alleging in recent times. So let's get your thoughts on that one.
Absolutely. I take it from the last. If the panel agree with the allegations and then find that the governor is culpable, the law is that as they return that finding, to the House of Assembly. All they need to do, and of course expect that will happen, it will be easy for them because they are all together. All they need to do is to lay that and then pass a resolution of 2/3 accepting that finding. And then is that the Constitution, the governor stands removed immediately upon the passing of that resolution. So that's why I said it's even the end of the judiciary that is more critical in this regard, where the executive and the legislature, right, they are fighting. It is the judiciary. It's the chief judge constituting the 7-man panel, and the outcome of the hearing of the 7-man panel. That's even the core of the thing. It's not the allegation. Because if the 7-man panel come up with a finding, then of course Mr. Governor is almost out, because when it returns to where it came from, except when they go back to get the 2/3, they are unable to get the 2/3. And what step will the governor take between the time of the ending of the hearing and when the House will reconvene for that resolution to be able to get, anyway, that's politics, to be able to get some members of the House back to his side where the House will not be able to get the 2/3. That's the only way he will survive. Because even if the 7-man panel find reason and find merit in allegations, right? And it gets back to the House, and the House is unable to get the 2/3. It also ends there, or the governor will remain.
All right. My time is almost up. Do you have a final say? You want to have in this a final word? You want to have in this?
Yes, absolutely. The final say is that let there be peace in River State, and let's shoot our swords, and let all of these they are unnecessary and they are avoidable. Really, if you ask even on the street, what exactly is even happening? We seem not to fathom that. What exactly is the problem between the House of Assembly and the executive? We seem not to fathom that. In less than 9 months, all of this trouble grew. And up till now, they have not even celebrated 1 year. They were all in the same political party, even if the 27 members have gone now to the APC. But can we have peace in River State and let governance continue?
All right. Let governance continue. Thank you very much, Ekine, National Legal Advice Committee for the Defense of Human Rights. It's a pleasure having you on the show.
Thank you very much. It's always my pleasure.
All right, then. Okay, keep speaking and don't get tired. But let's take some messages. My goodness, the phone line's almost crippled our conversation, but we came out victorious. Sylvester Madu says, what goes around comes around. Chibundu Oroko John says, if Sim is to be the brother of those people called the lawmakers, what would be their decision? Honorable Valentino Maka says, peace is vital in River State. Let's talk about love, joy, and peace. We say no to political atheism, political racism. I see a new River State where every youth is looked up to. I see a new River State where every youth is recognized and honored. I see a new River State where every political godfather calls for peace. I'm not a preacher of war, but a preacher of love, joy, and peace. Okay, with the voice of River State, bless us all. All right, let's go to WhatsApp and let's see what we have there on WhatsApp. This one says, as very, very pertinent question, also to know how it amounts to impeachment. Perhaps we have gotten how verbal attack. As it's a remark of your guest, let there be peace in River State. That is where Comrade Clinton stands, and maybe that's why I stand as well. This one says, this one says, good evening, Canada. Please ask the lawyer, did the lawmakers send their resignation letters from PDP to the APC to Edison a year in the parliamentary session? Has the House ever sat where each of the defecting lawmakers sent in their letters of defection to the then Speaker Edison a year? Please, we should have a community reading of Section 100 of the Constitution from Ibiba. Okay, this one says there are political cases in every state, but the media do not really give it importance. How does the crisis put food on the table of people in the state? It is boring to be talking about it every day, and we are not learning anything. Ayibatoya, are you saying you didn't learn anything today? And by the way, I've learned that the lawmakers on their own cannot cause an impeachment. So the only way politically, I'm thinking, that this can swing to any side is who is going to be, friends. Maybe politically, I'm saying politically, who's going to be friends with and the other party, you know what I'm saying. This one says, may Anambra not happen to River State? May we not have Chris Ngige and Uba? Hope Wike is not playing the role.
Say goodbye to charging fees with Infinix Note 40 fast charging, ensuring you're powered up from boardrooms to hangouts. Enjoy the stunning 108 megapixel iOS zoom camera and capture memorable moments every day. There's more. Purchase the Infinix Note 40 and get a 3-month